Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
The attorney of fact.
Attorney what?
Of fact.
Attorney of fact. And what does that mean?
You know, his authorization to do legal work.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? Pardon?
I'm the attorney of fact for the respondent in the area.
Well, let me explain to you. Only an attorney at law can stand in court and represent a criminal defendant. And to do so otherwise violates the criminal law statutes of the state of Tennessee and could land someone who attempts to represent themselves as an attorney at law in serious trouble. I understand what you're saying. I understand you're saying an attorney in fact. And what I want you to understand is that if you have a power of attorney, then you need to demonstrate that power of attorney. Do you have a legal document called a power of attorney?
No, I do not at this time.
Okay. Then you don't have any authority to act on behalf of Matthew Aldridge in this court. You have no legal authority, nor do you have any authority through a legal document to represent or to act on behalf of Matthew Aldridge.
Why did the court just let me file this document?
Show it to the bailiff and he'll show it to me. Apparently there's a copy here.
Yeah.
All right. This is in the state of Tennessee of Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court because this is circuit court. You just be quiet.
You go to the courthouse, it comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it said, as well as it being a maximum law, citing certain Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel, waiver, and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the respondent in error signature.
All right. Well, I find that Matthew Neal Aldridge has failed to appear personally in this court for the plea day on his case, which is set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neal Aldridge. If you are, in fact, Matthew Neal Aldridge, then you need to say so and stop this nonsense because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally on what we call our last plea day before his trial date tomorrow.
Question. Is that an Article 3 trial?
To what?
Will that be an Article 3 trial? A trial by jury with jury?
It would be a trial by jury. Certainly it would be. but I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you're wasting valuable time to all of these other citizens who are here today. So when I'm talking, you stop talking. No, you will when I'm finished talking. You're wasting the court's time by doing this, and I'm just simply instructing you that if you are, in fact, Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately, it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge. Now, is there a possibility of leaving the jury warrants? If you put a notice up there tonight, if they don't read you tomorrow, but they read you on February the 6th. February 7th would be a day I could give it. Is that possible? General, we're going to need to set a trial date in July.
July 15th.
I'm sorry?
July 15th.
July 15th. Right. To Matthew Aldridge and the individual standing before me whose name must not be uttered, then we will set a July 15th trial date for Mr. Aldridge. Whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore I'm denying whatever that might be in the way of a motion. The trial date will be July 15th. The last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are, in fact, Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get this card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will be will take place with him in jail, incarcerated on the 15th. That's the judgment of the court. You need to take your piece of paper and go on about your business.
Do you agree with this decision? Comment your opinion, like the video, and subscribe for more real courtroom moments.
The biological father of a child born to the plaintiff, Katie Levine. At the outset, Mr. Rowe explained that he originally believed he was the child's father because the plaintiff had represented to him that he was. Based on that understanding, he accepted paternity at the time of the child's birth. However, after the couple separated approximately 1 year prior to the hearing, Miss Levine informed him that he might not be the biological father. This revelation prompted Mr. Rowe to pursue private DNA testing, which returned a negative result. Seeking formal legal confirmation, Mr. Rowe petitioned the court to establish non-paternity through official proceedings. During questioning, the judge clarified key facts. Mr. Rowe acknowledged that he had been engaged in a sexual relationship with the plaintiff during the time of conception, which occurred around December 2020. The child was born on the 23rd of September 2021. Mr. Rowe stated he was unaware that the plaintiff had been involved with another man during the relevant period. He later learned that another individual, identified as Tyler Ellis, could be the biological father. The court reviewed a DNA test report dated the 26th of June 2023. Both parties present had no objection to its admission into evidence. The report was formally entered as Defendant's Exhibit A. The DNA results confirmed that Mr. Rowe is not the biological father of the child. During closing remarks, Mr. Rowe briefly mentioned that he had recently received a call from child welfare authorities indicating that the plaintiff's children had been removed due to concerns about parental fitness. However, the judge ruled this information irrelevant to the issue of paternity and did not consider it in the final determination. Counsel for the defense argued that the evidence presented met the statutory requirements under the applicable law. He emphasized that the child was under the statutory age limit at the time the action was filed and that the DNA evidence provided clear and convincing proof, excluding Mr. Rowe as the father. In issuing the court's findings, the judge summarized the testimony and evidence. The court acknowledged that Mr. Rowe initially relied on the plaintiff's representation of paternity, but later discovered, through both her admission and genetic testing, that he was not the biological father. The court found the DNA evidence credible and sufficient to rebut any presumption of paternity.